Hello. In this lecture I'm going to be talking about the philosophical justifications which have been put forward for intellectual property. It's a very interesting area, and it's one that I think will have you asking a lot of questions. It's also one where the examiner likes to ask quite a few questions, which is why we're spending time on it. What questions do we need to consider? Well, to start with, there is pretty obviously a huge question about whether creations of the intellect should be treated as private property in the first place. What are the consequences that flow from doing this? How are the interests of the different parties involved in the process taken care of? Where does the law strike a balance? Can we justify protecting intellectual property in the same way as we can justify protecting real property, or property in chattels, in tangible goods? Does the advent of digital technology make any difference to the justifications? And how does this work in the global economy? Well, I hope you're going to get some of the answers to those questions in the course of this lecture, but others are for you to think about. Let's look first at how intellectual property law works. Just in general terms, if you're at the beginning of an intellectual property course, then you've got a great deal to learn about the detail in the coming weeks and months. From a commercial point of view, what intellectual property does is make intangible creations of the intellect tradable. It turns them into commodities, it commodifies them. And it's done this at one level for a long, long time, in that, for example, copyright law gives authors rights, which they can then sell on some basis to publishers. And of course a similar thing goes on in lots of other areas too. But in the last couple of decades it's gone even further than that. So not only are these intangible rights traded themselves, but the products of those intangible rights, the books, the movies, the recordings, they too have become intangible, but they can still be traded. Well, whatever form the finished product, the intellectual goods take, the important legal right that we're concerned with is the intellectual property right which protects it. And if you're a big fan of property law, it'll mean something to you if I say that these rights are mostly choses in action. A chose in action is a property right that you enforce in the courts rather than by possessing whatever it is. Your motor car is a chose in possession, but your copyright, well, you can't possess it. It doesn't have any concrete, tangible form, so it needs some other way of protecting it. The way that all intellectual property rights work is by conferring monopolies on people. And do read the article by Sir Robin Jacob, which I'm going to mention later. It's quite a few years old now, and the examples that he uses in it, the illustrations, are certainly no longer current, but the basic principle still is. Anything he says is worth paying attention to, whether when he was in the courts or in articles and books he's written before and after that part of his career. And in that article he suggests that it wouldn't be a bad idea to stop talking about intellectual property protection and start talking about intellectual property monopolies, because that's identifying it for what it is and actually highlighting the fact that it's not necessarily a good thing. When you learn more about intellectual property, if you haven't already, you'll realise that intellectual property rights are monopolies of different strengths. Patents and registered designs are strong monopolies, they're true monopolies, because if you have a patent or a registered design you can stop somebody using it without your permission, whether they knew that you had it or not. And if they make their own invention or design which is the same as yours, that won't help them. Trademarks are monopolies too, but they're limited to the goods or services that are specified in the trademark registration. These days trademark owners very often specify as many goods and services as they think they can possibly get away with. So trademarks become more and more like a real monopoly, but they're not supposed to be. That's one of the things that Sir Robin Jacob is being critical about in his article. So intellectual property rights are monopolies, and monopolies are usually regarded as bad things. As far back as 1623, the Statute of Monopolies prohibited them, but then went on to carve out a little bit of space for what we would now recognise as the patent system, and other forms of intellectual property have grown up in that same bit of space. So in a sense, intellectual property rights are an exception to the basic prohibition on monopolies. And again, as a sweeping generalisation, like all exceptions in the law, they should be construed narrowly. What we need to look at is why it is appropriate for the law to grant this exception at all. Why should intellectual property rights be permitted? A lot of philosophers have had a lot to say about private property in general, and traditional justifications fall into two broad groups. Some philosophers focus on natural rights and regard the ownership of property as being part of the natural order of things. Others focus on how granting property rights can give incentives to people. If you allow somebody to own a piece of land, then they'll grow food on it, and they might be able to feed a wider number of people in their immediate family. There's a lot more to it than that. You can't divide all these theories into two neat groups, but that's a good starting point. Once you start to drill down a little bit, you'll find that there are some variations. In the natural rights school, you have John Locke propounding his labour theory of property. There's a variation on that. You have other philosophers who suggest that the right to own property is all based on what the individual deserves. Looking at the incentives that are available, the classic statement of the philosophical basis of property for giving an incentive is the utilitarian approach, the greatest good for the greatest number. But you'll also find philosophers focusing on the fact that individuals need to own property in order to preserve their sovereignty, dignity and security, or because their property is tied up with their personality, or because it all helps to lead to what is sometimes called a just and attractive culture. And before moving on, I should also mention that in the intellectual property field, particularly in connection with copyright, there is an important consideration about free expression. Years ago, when artists and writers and musicians were often court employees, their job wasn't necessarily to say or paint or compose what they wanted, but it was to do what their boss wanted. They made their living under a system of patronage, and of course, if you're in that situation, you've got to please your patron. Taking them out of that equation and giving them legal rights which they could then sell to publishers and allow all kinds of people to enjoy, set these creative people free. So there's a significant case for copyright to be made under that heading, perhaps for other types of intellectual property too. You can read a great deal about these topics. There are many, many articles, a smaller number of books, in fact I think probably only one book. And intellectual property textbooks have also got material on this topic in them too. But to help you get more deeply into it, I would recommend Ned Hettinger's article, which I've listed on one of the slides, and I've given you a link to where you can download it from. It's not too long and it's quite accessible, but funnily enough it's quite critical of the way intellectual property law is developed. Bear in mind when you read it that he's an American philosopher writing about American law, so how helpful that is to a student of English law, you have to judge. But these are all on general issues, not on specific issues of the law. Then there's a book called The Philosophy of Intellectual Property by Peter Dreyhus. It's actually about 20 years old, but it was republished in 2016 in electronic form by the Australian National University, and you can download it from their website. excellent book. It is about 250 pages, so you might not have time to look at it, but if you can make the time, I do recommend it. Finally, the article by Sir Robin Jacob that I already mentioned. I haven't got a link to that, but you should be able to find it in your institution's library or online library, and it's well worth reading. Also not too long, because originally it was a 1-hour lecture. So let's look first at the natural rights approach to intellectual property and start with the labour theory of property advanced by John Locke. You'll find it in his second treatise on government. It doesn't actually take up a great deal of the book, and I think it's fair to say that it's actually what people have done with Locke's ideas since his time that's most important to you, because Locke was writing in the 1600s, 20 or 30 years before the first Copyright Act in this country, a long time before modern patent law started to take shape, and at a time when the idea of a trademark would probably be utterly incomprehensible. In fact, the Industrial Revolution didn't even get underway until the middle of the century after Locke had been active. So when you read what he says about property, or you see his ideas applied by later writers, always remember that what he was thinking of was an agrarian economy. He's thinking about people occupying plots of land, clearing them, cultivating them, growing crops, harvesting the crops, picking apples from the trees, using the wood from the trees to make furniture and houses. This is the world in which his theory works. It doesn't take into account copyright or patents or trademarks. It tells us a lot of useful stuff about them, but it certainly wasn't what he was thinking of. You could say that his basic idea is that if you made it, it's yours. That's what the labour theory is all about. We own the products of our work. We own what we create by cultivating land, and in fact we derive a claim to ownership of the land from cultivating it, and we own what we create by harvesting crops. Our labour is mixed with unowned objects, objects which until that time had been held in common. Common is a very powerful concept, and of course in Locke's time there was a lot of common land. Ordinary people had the right to graze their pigs and cattle on the common land, and they had their own plots on which they could raise crops and things. And what happened in the agricultural revolution in England was that the landowners started to enclose the commons, and in Scotland a similar but much more draconian process took place some time later, the Highland clearances, all about landowners asserting their rights to land which had previously been in common. And if instead of talking about land you talk about ideas, you can see how intellectual property law brings about a very similar result. Anyway, going back to Locke, to put his proposition more formally, individuals own their bodies and the labour, and the labour becomes infused with an unowned object, with the result that the rights which the individual owns in their labour expand to include the objects that they've laboured on. You can't deny that it's got a certain logic and a certain attraction, and it works okay in an agricultural economy. However, there are many objections to a rigorous adherence to Locke's ideas. There are references here to more articles and books and things. Waldron says that the whole idea is incoherent. Labour and objects are like oil and water, you can't mix them. Proudhon, the French anarchist, who famously said property is theft, makes the point that if labour is the important thing, why do you discount the contribution of a second labourer? Well, one answer to that is probably, in Locke's time, if labourer 1 had ploughed the field labourer 2 couldn't plough it as well. They'd have to go and find their own field to plough. But if inventor 1 creates a wonderful new vacuum cleaner, and inventor 2 independently creates an identical one, they've both put in the same amount of labour, and on Locke's theory they should both own something at the end of the process. Patent law doesn't recognise that, doesn't work like that at all. There can only be one inventor of an invention. A second guy that comes along with the same thing doesn't get anything. Then we've got Nozick's objection in his book Anarchy, State and Utopia. Why do we say that the labourer gains the object when we could just as easily say he loses the labour? And Nozick then famously makes the point that it's rather like throwing a can of tomato juice into the ocean and claiming that you own the ocean. It's certainly fair to say that the result is strange if no account is taken of the value of the labour put in by the labourer. They might do very little to the object to make it their property. They might just pick an apple out of a tree. And Locke tries to tell us that almost all the value of the apple lies in the picking. It's the labour, not the object, that's actually valuable. And insofar as the apple sitting in the tree waiting to be picked isn't actually worth anything to anybody, there's a certain amount of truth in that. But it's still fair to ask how much of the value of the object the labourer should have, the person who applies their labour to it. Because after all, what they're doing is mixing two things together. They're mixing their labour with the object. And instead of saying that means that the object becomes theirs entirely, it could be that the labour, the effort that they've put in, becomes diluted, and they get rewarded with something less than full ownership of the object of their labours. And then what if they're using social products in their work? What if they're taking advantage of the infrastructure that's been built, the roads, for example, energy networks? That too somewhat undermines the claims to private ownership. So Locke's theory, attractive as it is, certainly doesn't answer all the questions about property, and that's before we've even gone into looking at intellectual property as a separate issue. There's no doubt that these natural rights theories can justify at least some intellectual property protection. It doesn't help with trademarks, because trademark protection doesn't reward the labourer, doesn't reward effort. Trademarks aren't creative, they're not inventive, they simply do a commercial job. Okay, I know there is creativity involved in a lot of trademarks, but it's rewarded in a different way. There will be copyright in the creative elements. And a trademark to be protected doesn't need to be creative. But when you look at patents and copyright, there's certainly a more compelling case for saying that there's a natural right to protection. But if you accept that, how do you accept the fact that the law says that that protection is going to be limited in time? What about the fact that the law says that if you want protection you've got to apply for it? You don't get a patent automatically, you've got to go to the patent office and ask for it. And moreover, you've got to pay for it. So if it's your natural right, surely there should be no costs associated with obtaining the monopoly. Some of these objections are dealt with by taking a slightly different view and focusing on what people deserve. Instead of asking whether I've got a natural right to something, ask whether I deserve it. I might be a naturally gifted athlete, I wish. But do I deserve to have that ability? But following on from down this line of reasoning, the proposition, obviously extended from Locke's theory, is that the labourer deserves to benefit from their labour. They spend their time ploughing the field, growing the crops, picking apples. They should get something back for that. But what they get back doesn't necessarily have to be property. There are other ways of rewarding people for the labour that they put in. Labourers don't actually want property all the time. Remember, I'm using the word labourer in a very, very broad sense here. Instead of property, they might just want admiration. They might want to be acknowledged as particularly good in their field. And if they do want property, if they do want to own something at the end of the process, they might find that the value of what they own is out of proportion to the effort that they've put into it. They might have had to work particularly hard, or actually they might have had a very easy ride. And you've also got to acknowledge the fact that individuals are not all the same. Different people's efforts produce different results. I can put a lot of effort into running, but I still get beaten by people who look as if they're having a far easier time of it than me. Well, John Locke did think about some of the objections to his original theory, and in the second treatise on government he explains that there is an important proviso. So somebody who labours on a piece of land or picks apples out of the tree can create a property right, provided that enough and as good is left in common. So the next person who comes along wanting to plough a field can plough the neighbouring field. There's still enough land left to go round. The next person who comes along wanting to pick apples can get apples out of the same tree. There's still enough to go round. Well, not necessarily the same tree. It's incumbent on the people who are applying their labour not to waste anything. So don't fence in more land than you can plough. Don't pick more apples than you can deal with. Giving people private property is okay, provided it doesn't worsen another person's position. There's got to be some land left to cultivate or apples left to pick. And here you can really see how Locke wasn't thinking about the intellectual property system at all, not surprisingly, because it didn't come along for several hundred years afterwards. The patent system doesn't leave anything in common. The patent system rewards the first person who comes along, and it gives that person everything. Everything that is within specified limits. So it's still open to the next person that comes along to make a vacuum cleaner that doesn't fall within the scope of the first guy's patent. But that's a rather different notion of enough and as good from what Locke was talking about in the first place. Compare the copyright system. That's very different. Copyright recognises that two people may create something that's pretty well identical. They might write a story which has many of the same features. It might be based on the same fundamental idea. And because copyright works on the basis that there is copyright in the expression, the actual form of words used to tell a story, or the notes used to compose a piece of music, or whatever it might be, the expression, not the idea, is what's protected. It really works quite well at meeting the requirements of Locke's proviso. Enough and as good is left in common for others to work on. Anybody else who wants to work on that idea is still able to do so, notwithstanding the fact that somebody has already told the story in their words. In competition with the natural law approach is utilitarianism, a positive law approach which recognises how the law can be socially beneficial. And you'll find the basic ideas of utilitarianism expressed by John Stuart Mill and, to a greater extent, by Jeremy Bentham, writing well over 100 years after Locke, and in a very different era when industrialisation was in full swing and politics was changing dramatically, so was society. The touchstone for any legislation in the utilitarian world is that it should deliver the greatest good for the greatest number. Things aren't going to be absolutely good or absolutely bad, but the important question is going to be whether the sum of happiness in society is going to be increased as a result. So the utilitarians would promote creation by granting limited rights. If you read the Constitution of the United States of America, you will find there's a clause empowering Congress to pass copyright and patent laws, which says precisely that. Congress can have power to do these things to encourage people to write and invent. and give them exclusive rights to their writings and inventions for a limited period of time. Being given these rights doesn't guarantee success, of course, but without them you're bound to fail. It's hard to tell how well this utilitarian approach works, whether it actually does optimize social utility, because you can only tell whether it's doing that by empirical evidence, and it's very hard to measure. But it has been hugely influential in the United States, in particular with their written constitution, but also on the rare occasions, or perhaps even rare single occasion, when the English courts have had to consider the justification for intellectual property, a patent case, Draners Alstat against Hayek, the court adopted a very utilitarian analysis of what the patent system was all about. It also provides a way of justifying copyright, because you grant limited rights to writers and composers and artists and give them an incentive to carry on producing. It even provides a justification for trademarks, which really don't fit under any natural law theory, but they do help with social utility, with the greatest good for the greatest number, because they convey lots of information very efficiently to consumers, and as economists would say, and indeed many economists do say this sort of thing, they minimize consumer search costs. So there's a social benefit to trademarks, which only works because the trademark owner has got certain exclusive rights and is therefore going to be the only person in the marketplace with that trademark. The only area really where utilitarianism doesn't help explain how intellectual property works is with trade secrets and confidential information. They're rather hard to justify, because giving people a monopoly over trade secrets doesn't actually give them an incentive to do anything, to create those secrets. The fact is that those secrets have come into existence and they're just being protected as a matter of necessity. Having said which, the ability to protect trade secrets and other types of confidential information is extremely important, and that in itself could be analysed from a utilitarian point of view. The fact that businesses have the ability to protect their trade secrets is an important aspect of a functioning society and is going to help optimise social utility. Commentators looking to justify private property have long focused on sovereignty, dignity and security, the fact that property is needed to meet these basic human requirements. You need shelter and you need nourishment. And people do try and apply these principles to intellectual property, but it's difficult to say that convincingly. It's difficult to put forward the proposition that owning intellectual property is necessary to sovereignty, dignity and security, in the same way that shelter and nourishment is. Intellectual property can be useful, it can help you earn a living, but it's not a basic human requirement in the same way as a roof over your head and food on the table. And in fact there is a further objection to applying this approach. If the patent law allows you to stop other people using their inventions, in inverted commas, and creations, then it could be detrimental to their dignity. So if you read the Hechinger article, for example, you'll find not a lot of time is taken talking about sovereignty, dignity and security as a justification for intellectual property. In another approach, Hegel in particular argues that intellectual products are an extension of one's personality, that individuals have moral claims to their talents, feelings, character traits and experiences, and to actualize these externally. In other words, I think you could say to turn them into something concrete and tangible requires some sort of property right. It's by controlling objects, in the very broad sense of the word, that the individual's will is allowed to take form, and through that individuals attain freedom, which sounds extremely nebulous, but if you go back to the sort of person that John Locke was writing about, you can think in terms of somebody using the wood from a tree to make a chair. It might be a very ordinary and functional chair. It might be a very artistic, high-class chair. It's got something of the maker's human experience in it, and it's helping them, perhaps in a very small way, to attain freedom, freedom to be able to sit on it, or perhaps the freedom to sell it for a lot of money. In any event, the point here is that an individual's personality becomes fused with the object. This all rather begs the question of whether we actually own our own feelings, and rather like Professor Nozick's tomato juice, it could be argued that instead of extending our claims to feelings and so on to the objects, we might alternatively say that the feelings have been abandoned. In some societies, the person who labours over making a nice, comfortable chair pours their soul into it, but doesn't get anything at the end because it's taken away and used by somebody else. It becomes communal property, perhaps. The maker probably gets a different form of satisfaction, but it might not be something that Hegel would recognise. The point also made that personality-based claims don't justify property, and we'll see this at many points in the intellectual property course that you're doing. But let me just mention at the moment that in copyright law we have a whole set of rules devoted to protecting the moral rights of authors alongside their economic rights. They're not property rights, but they're quite an important adjunct to property rights, to economic rights, and they recognise that the author of a copyright work has got some claim that their personality is involved. Finally, we'll come to the just and attractive culture argument, which says that property rights can and should be shaped to foster the achievement of a just and attractive culture. Interestingly, this is directed to questions about what to do with property rather than whether it's a good thing to have property to begin with, so it's a rather different way of looking at things. It's an approach which has been taken by Thomas Jefferson, by Karl Marx in his early days, by the legal realist school and lots of other philosophers, particularly the proponents of classical republicanism. There's a sort of idealism involved there when you talk about a just and attractive culture. It's not far removed from the utilitarian approach, but it's a wider concept than the utilitarian's idea of social welfare. However, social welfare itself might be hard to measure. Economists have got ways of doing it, so you can tell when utilitarianism is working, but who's got a yardstick to measure a just and attractive culture? Different societies through history have got very different ideas about what is just and attractive in cultural terms, and just between democracies and dictatorships there's a big gap. But it's certainly something that intellectual property can help with. Copyright law is very much tied up with culture, and indeed that illustrates rather nicely how these different justifications apply to different rights. Intellectual property laws never distinguish good from bad. Copyright law protects great music and mundane music, advertising jingles. It protects popular music and unpopular music, and I don't think anyone would seriously suggest that it shouldn't. Patents will protect blockbuster drugs that could change the lives of many people suffering from some disease, and also, in a memorable example that I came across once, a technique for creating works of art using the nose of a dog. It's not the job of the intellectual property system to distinguish between good and bad, but some of the justifications we've been looking at look a bit shaky when you take out of the equation how worthwhile the intellectual objects that are being protected are. If the examiner asks you a question about a single justification working for all types of intellectual property, then you'll be able to say that different types of intellectual property rely on different justifications. The natural law model works quite well for copyright, including moral rights. The utilitarian approach justifies giving limited monopolies through copyright and patent laws to give an incentive to create. A utilitarian can also recognize the social value in a trademark. Even though it's got no creativity or innovation in it, it does a useful job by minimizing consumer search costs. Trade secrets require some other sort of justification, but they're not property in the strict sense anyway. Well, there is a wealth of material that you could read on this topic of justifying intellectual property rights, and I haven't even dared to get into a Marxist critique of the way intellectual property works. That's something for another session. But I hope this lecture's got you off to a good start, and that it's fired up your interest to look further into the topic. Thanks very much, and I'll speak to you again soon.